That being said, this is the criminal warrant application hearing calendar, and that's particular to the state of Georgia and a handful rather of other states where they allow private citizens to pursue misdemeanor warrant applications against other citizens. Okay, but again, in the event that I subsequently find that there is probable cause, then I'll talk about the potential parameters for you turning yourself in. In the event that I do not find probable cause, all right, then this matter would very well be dismissed, and that would be the conclusion. Okay. Furthermore, in the event that I find probable cause, it is still going to be up to the solicitor, the state solicitor, or county solicitor rather, to determine whether or not they want to take up the case and pursue it. So we can focus what we're doing here. We're here regarding the allegation of the transmission, rather explicit photographs, as well as harassing phone calls. These allegations have occurred back on July 6th, 2023. Again, this is an allegation made by Sheena Goodwin, here identified as Sheena Johnson, versus a Mr. Jeremy Doan. What I'm going to do, ma'am, is give you an opportunity. Now is 6:57. I'm going to give you no more than 3 to 5 minutes to be able to tell me the subsequent facts or allegations generally that are arising or led to the July 6, 2023 incident.
Okay, thank you.
It's 6:58, so you got to 7.
I understand. Your Honor, Jeremy and I were in a relationship for almost 4 years. The relationship ended with Jeremy being extremely abusive. Since the relationship ended, Jeremy has continued to contact me via cell phone or even on email, and I've made police reports to every single one of the encounters that have taken place from, I would say, July of 22 all the way up until the most recent incident. Now, the photographs that Jeremy submitted to my job back in December of last year, Jeremy sent an email to me at my work email of one of the photographs, but he didn't CC anybody else on the email. So I was able to, gain access to it immediately and delete it from the entire email trail before it raised any flags because it was a nude photo. Now, I contacted the authorities and put in place a police report regarding that incident back in December of last year. I believe it was December 7th. Beginning early May of this year, Jeremy contacted me via an email and said that he's going through a security clearance for his job. And for some reason, the detectives somebody's going to reach out to me for character witness purposes because it shows in the system that he used to reside at my address with me. So we went back and forth on email a little bit at that time. He asked me how I was doing and so forth. I told him I'm doing great. I'm actually getting married in June. I said I'm getting married in June or this summer or something of that nature. I don't have those emails anymore because I deleted them. Actually, my husband deleted them after reading them, but Jeremy may have those emails to be able to submit to you. He was extremely belligerent in the emails as usual. Next thing you know, July 7th, I wake up to my boss contacted me at 2 something in the morning telling me that I sent emails from my work email and it has a copy of my ID. What are you talking about, to my boss? And then she further looks into the email and sees 7 naked photos of me. Jeremy submitted 7 naked photos of me, made up an email address as sheena.n.johnson@outlook.com. But my email at Kaiser is sheena.n. He almost made the email addresses identical, but the difference this time is he CC'd every single one of my executive directors and vice presidents that he knew I worked for. He knew I worked for the selected individuals because he has once upon a time tried to get employed through Kaiser and has made contact with them. In addition to that, Your Honor, 4 days before this happened, I get a ping on LinkedIn that somebody by the name of Yusef Robinson is looking at my profile, which is my kid's father's name. My kid's father doesn't know anything about a computer, for one. He and I are really great friends. He actually came to my wedding with my daughters. So, and more than anything, he's never in his life seen these photos that were submitted. The only person who ever had sole access to these photos were Jeremy Doan, which is the individual I sent them to when we were in a relationship together.
Okay. All right. Give me 1 second here. All right, thank you. I'm going to now let Attorney King or Attorney Kim here present their opening.
Well, you said opening?
Well,
or you want me to cross or?
No. If you want to have an opening, that's fine. Otherwise, if you don't have to have an opening. But we're not crossing yet because she hasn't the evidence. But so it's up to you. This was just a general introduction. Obviously, Some people don't have counsel, so they have to give me a statement of what their position is, but it's up to you.
We don't have an opening, Judge. We would like to see, obviously, and this, I guess I'll say a couple of things. We deny the allegations. I haven't seen anything that would be considered to be proof in order for me to even scrutinize. We deny the allegations. And I would ask, if there's an IP address, has this been investigated? Is there a way to, show that are the witnesses here to say that they received it? So these are the types of things that I'm just not sure about, if that even exists. But we deny the allegations and look forward to reviewing whatever is presented.
Okay. All right. With that being said, Ms. Goodwin, tell me the evidence that you emailed. I did see an email with some Excel spreadsheets that had identification of some calls. What else did you email the court in regards?
I emailed the court a copy of the forensic report from Kaiser's forensic department. My job did a complete investigation regarding this, of course, because of the audience that Jeremy sent these emails to. So there is a forensic report with all of the photos that I emailed to you guys. Now, with Jeremy's nature of employment, working in cybersecurity, Jeremy knows how very well to scrub IP addresses, which is what he did. However, the forensic department at Kaiser was able to detect as much evidence as they could and provided a report that I sent to you guys. And if an attorney like Jeremy's would like to go and investigate further, he would have access to being able to disclose the IP address and the location.
Okay.
And then there's probably 7 different police reports that were submitted also to you, Your Honor, in regards to like the harassment and the phone calls, and even back to the incident back in December from the police department.
Okay, hold on. A password for this CFI report of findings? Because
There is, it is password protected. I will message it to you right now, actually.
Okay. All right, I'm looking at this report in council. I'm going to share it, but it's an extensive thing here.
There's images on there, Your Honor, that
I'm not gonna post these images. Don't worry about it. Now, and so council, I'm going to tell you what we have, and based on the nature of it, we're not going to share it. I just want to make sure that where specifically, ma'am, are you alleging that there's information that identifies Mr. Dunn and is the person who's done this?
Okay, so Your Honor, on the forensic report, it does not state that Jeremy Doyne is the one who sent this because he scrubbed the IP address. But Your Honor, listen to me. I was in a relationship with this man. I know who I sent those photos to. My husband has never even seen those photos of me. Nobody else has ever had access to those photos of me, but the one person I sent them to, which was Jeremy.
Okay.
Only person.
All
And
right.
the only reason to this day, right now, I regret so much not pressing charges on him when they arrested him in March of last year for domestic violence against me and a lot of other physical.
Hold on. I don't want you to continue to testify. So what I'm saying is, so counsel, let me just make sure we put this in proper posture here and you understand what evidence was submitted. She submitted a report, which I've seen, which is essentially a report associating with the allegation. So this did happen, counsel. I can't confirm that it did happen, but the report does not specifically identify Mr. Dunn as the individual who sent these particular emails. It doesn't identify the source, but it identifies that it did in fact occur.
Understood.
All right. So with that being said, Ms. Johnson, do you have any other evidence that you'd like the court to consider beyond that particular report?
Yes, the police reports that were submitted over to the courts for the harassing phone calls backdated from August of last year all the way up until May of this year.
Bear with me here. All right, Ms. Goodwin, this is what I have that was brought. Counsel, do you see this? This is now it doesn't identify who the witness is or who the victim is, but it just identifies that there was a charge. Is that what you're referring to? Because I don't have any police reports.
No, I submitted them to the courts when I first submitted the warrant application. I have them on my email. I can submit them over to you now.
Well, let me ask you this, because obviously I'm very particular about time, but as well as respect. What dates are these incidents for these police reports?
The police reports date ranges from August of last year all the way up until December 7th of last year, which was the last incident before this one took place in July. It was 6 different incidents where he was contacting me, harassing me via email or telephone, where I had placed police reports. Police officers came to my house.
I got that. Now, those are different incidents. but the incident that we are dealing with today, you were alleging occurred on July 6th. Are you saying that July 6th has something to do with all of those other incidents? Or are you saying
It's been ongoing. It's been ongoing. It's just been ongoing harassment. The July 7th one, which is when he submitted those pictures to my job. There's also a police report.
Well, that can be within that. That alone can be within that. I mean, you can send those to the clerk, but what I'm going to have them do now, if you don't have a specific one, let me ask you, do you have a police report for this event, this July 6th event?
Yes, the one from the pictures. Yes, I do.
Okay. Clerk, if you can find that, if you don't, Miss Goodwin and Ms. Johnson, can you please provide those or email those to us now? But what I'm going to allow to do now, since you don't have any other witnesses or any other evidence, I'm going to allow Attorney King to cross-examine you. And just so you're aware, cross-examination is essentially, it is as we call it, a hostile event. And that means he may ask you some questions. I'll be here obviously in some ways to referee, but nonetheless, you are allowed to answer those questions. All right, counsel, it is 7:10. I generally don't like people to be hammered forever because obviously that can go on. And we can try to give you no more than 5 to 8 minutes, depending upon what's going on. Obviously, there wasn't a lot of testimony that was presented. Floor is yours.
Judge, I just wanted to make sure that you read that correctly. That was a notice that no accusation would be filed. Okay. All right. I misheard you. Miss Johnson, is that's your last name now, correct?
No, Goodwin is my last name now.
Okay, Miss Goodwin. You spoke to the police regarding the photos in this case. What police department did you speak to?
DeKalb County.
Okay. And have you spoken to anybody regarding that case since you filed the report?
No.
Okay. Did you follow up with them?
They followed up with me in regards to the report and advised of this hearing that would take place.
Okay. Did they explain why they decided not to take out a warrant themselves?
I never asked.
Understood. Well, I was just wondering, did they say anything about it?
No, and I never asked.
I understand. So are they the ones who advised you in order to take out this warrant?
No.
So didn't you just say that they spoke to you about taking out the warrant application?
I said that they spoke to me about the case. Sir, you asked me, did I speak to anybody else behind this regarding the case? The police department, that's it. I'm the one who researched how to take out a criminal warrant application against somebody because that's one of the rights that you have out here in Georgia. You can do that. And I learned that when Jeremy put his hands on me back in March of last year when he was arrested. Did
the police indicate that do you know the status of the investigation of this by the DeKalb County Police Department?
No.
Okay. All right. So you state that, so the harassing nature of the communications that you're speaking of in your warrant application is from 2022, not from 2023. Is that correct?
That's incorrect. It happened in 2023 too, all the way from 2022, including 2023 with the most recent case.
Okay. So how often was he calling you, or how was he communicating with you in harassing nature? It
was via phone up until December of last year until I changed my phone number. Then it continued via email.
Okay. And what's the proof that you have regarding those allegations
when it
continued through email?
Reports. I have police reports.
Well, the police reports are not proof. I'm asking the proof.
Well, I don't have the emails, but I don't have the emails because I tried to delete Jeremy from my life completely. Okay. I like out of sight, out of mind for me. Up until he did what he did with my job, all gloves are off. I'm not protecting him anymore. I'm not hiding how he abused me. I'm not hiding nothing. So I'm pretty sure, sir, if you asked your client, pretty sure he has copies of all the emails that he is.
Miss Goodwin, listen, you just answer the question.
Okay.
Honestly, you get an opportunity to explain, but not an opportunity to be combative. Okay. So
okay, got it.
He doesn't have to answer any questions.
All right. So the employers was it multiple employers or was it one employer that received your the communications in July?
I'm sorry, you went out. I didn't hear you.
I said, was it multiple employer, like multiple supervisors, or was it one person? How many people received the communication?
I believe it was between 7 and 9.
Okay.
I can look at the report to get the exact number for you.
No, that's just roughly, basically. And based on the investigation, it was determined that it happened, but it wasn't able to be determined with proof who sent them, correct?
I can't answer that. I'm not sure what happened with the investigation. I have no knowledge of what has taken place since I filed a report against him.
So at this point, you don't know. Obviously, you believe, I understand that you believe that Mr. Doyne sent these messages, but would you agree that there's no proof that he did it?
Absolutely not. I know he did it. He's the only person who had access and who I've ever given those photos to. I know. You know how you know if you send something to somebody in particular, the only person who had access to something that private? I know for a fact.
So with that being said, those photos had to have been in some sort of database, whether they're on your phone, whether they're in the cloud, they had to have been somewhere. Would you agree with that?
They had to have been inside of a camera because they were taken at once upon a time. Yes.
Okay. And so there's still a possibility that it could have been accessed by someone else besides him.
No.
Why not?
Why would it be? Why would somebody think off the top of their head, let me access this lady's phone to gather these pictures and send these to her executives that she works for right now, who I've been working for as I was with Jeremy. I don't deal with multiple men, 2 men at a time. I don't have those type of issues. So out of the blue, why would this just occur?
Well, I mean, you're answering a question with a question. And
Correct.
I guess the point is that I'm just trying to make sure that there's nothing besides the fact that the photos exist and you had previously sent them that ties this particular communication in July to Mr. Doyne. Is that correct?
No, it does, because one of the photos that he sent in July is also same photo he sent to my job, but just to me back in December of last year. Same photo. But the difference is he didn't send 7. He only sent 1 of the images that he sent out of the 7 that he sent in July.
I understand what you're saying. So regarding the communications, when you mentioned that you have police reports, the police reports are reports of you alleging to the police that Mr. Doyne has sent these harassing communications. Is that correct?
No, because when the police officers came out, which they did each time, they took photos of my phone, of the evidence. They took photos of the email communication. They've even called Mr. Doyne on the phone about him continuously harassing me.
What I'm saying, the proof would have been something that you would have had to submit to the police or submit to this court.
It was proof that I submitted to the police. However, it's also proof when the police are sitting right here in my house talking to me and he's still texting me at the same time. You see what I'm saying?
No, I don't.
Okay, so if I'm sitting here speaking with you right now and you're in my house and Mr. Doyne is texting me, threatening messages as I'm talking to you in my house, making a report about him harassing me, the officers were there and seen that as well.
Okay, so where are the threatening messages?
They're inside the police reports that I've submitted. There's several different police reports, and I submitted all of them along with this warrant application to the point where they responded back to me and said, please don't submit any more evidence until we give you the information on the date of your hearing. I submitted everything. So I'm submitting them back to the judge now, actually, as we speak.
You said that specifically that there were text messages. Do you
messages.
have those text messages? Threatening text messages?
Not in my phone anymore, no, but the police have them in their record when they were out taking the report from me. They took pictures of my phone, of the messages in my phone at that moment. Now, like I mentioned earlier before, I tried to erase Jeremy completely out of my mind, out of my life completely. So I don't want to keep threatening, hateful text messages from a person. I don't want to be reminded of this person anymore.
Okay, understood. Did the police follow up? And I'm kind of going back and forth between two situations because one of them is the communication, the transmission, and the others are the harassing nature of communications. Regarding the harassing of communications, do you have any further conversations with the police on whether or not there would be any action taken against Mr. Doyne?
No.
Okay, why not?
Because honestly, I was stupid. I wish I would have. I always try to protect Jeremy, and I know his job is very important to him. I know he went through a lot of education to get his job. He puts on this front like he's the sole provider for his family. I try to protect him so much through all of the abusive cases that took place with me and Jeremy in police contact. When Jeremy did this with my job, and he knows this is the only way that I can provide for my kids, he knows what, if I would have lost my job, what that could have done to my kids. I'm not protecting him anymore. I'm not hiding anything. I'm not hiding the images from the abuse from my face. I'm not hiding any of that stuff. And if I promise you, sir, I swear I wish I would have kept all that communication. I wish I would have. I wish I would have. All I can say.
Understood. That's all I have for you right now.
Okay.
Judge, may I ask quickly inquire the applicant?
Well, hold on, counsel. Y'all can't double team this lady. I'm not
We're
gonna.
not double teaming. I just had some supplementals, just quick.
Well, again, and what I'm saying is y'all gotta pick who's gonna have the witness.
I'll send the notice to my colleague, Judge. My questions.
There you go. I appreciate it.
Yeah,
Just so we can have some consistency with that. Appreciate that. All right. So obviously, she does not have an attorney to give any redirect, right? So if you guys are done with her, then I can allow her to be done testifying, and then you guys can make whatever position or argument you'd like to make. But Ms. Goodwin, what I will say is, because of counsel in between that time of that conversation or that cross-examination, I did receive the police report from this particular incident date. She did inquire that was part of the evidence that she'd want to produce. So I am going to introduce that and share that screen. That may cause additional questions or not, but it may answer some questions as well. Hold tight. All right. All right, Ms. Goodwin, we have here this police report that was produced, and the date of it is the July 7th, 2023, crimes against persons. Obviously alleges the harassing communication, but more importantly, does have the allegations again about the prohibition of nude explicit photographs and the dissemination of such. But here is the important part, counsel and Ms. Goodwin. And so it's what the officers indicated that they discussed with Ms. Goodwin, as well as, I guess, what they ultimately had found or was shown to them. Ms. Goodwin, do you have anything else to say regarding this particular piece of evidence?
No, Your Honor.
All right. Counsel, have you had an opportunity to review this? I mean, this is essentially the report here. All right. Let me know if you've finished reading that. All right, and again, that's just another copy of the narrative. All right, counsel, any other questions that you have before I let this witness be done?
Ms. Goodwin, when's the last time you have seen Jeremy in person?
June of 2022, when he was June of 2022.
Do you know where he lives?
Alexandria, Virginia, from my last knowledge.
Understood. Do you have any idea, I guess, what you would consider is his motivation behind what we're discussing here today?
Yeah, Jeremy's really hurt at the fact that I left him alone. And Jeremy would always say this thing to me, red rum, which means murder. And that would happen to me if I ever left him. Jeremy feels as if like I am where I'm at in my life because of him for some reason. Jeremy feels like he sacrificed for me. But at the same time, Jeremy also knows that if any of this was to ever come out, it would ruin his career. It would ruin anything that he's trying to do for himself. He can be a nice person, don't get me wrong, but he has a very evil spirit about himself. And he would try to hurt me and take me down no matter what. That's how Jeremy is. So the end is just to see me hurt.
I understand. Nothing further.
All right. Thank you, Ms. Goodwin. All right. Well, counsel, it's either your position to present any evidence or you want to make an argument. This is the case in chief.
Thank you, Judge. At this time, I would like to make an argument, and that argument is that the applicant has not met her burden here. I understand, based on the evidence that was submitted that the court reviewed, that something did happen regarding the communication to employers at Kaiser. And it's obviously clear that the applicant believes that it was my client, but the problem is that the proof is not there. There is no proof. And because there's no proof, I don't believe that we should be placed in a situation in which he has to defend himself in an application when the proof is not even there for her to meet her burden. I understand that they were in a relationship. There were communications between the applicant and my client regarding the photos that had been sent in the past. However, that does not mean that those photos were not accessed by someone else. And I'm not here to speculate if that happened, how it happened, when it happened, where it happened, and through, what means. But I can tell you that there would need to be some sort of proof that my client submitted these photos to her employer. And there is absolutely no proof. The applicant, her only, I guess, connection is the fact that she knows that my client has seen these photos, has received the photos, but that doesn't mean that he's the only one. And that is, and I'm not trying to say anything about her because I don't know her, but that doesn't mean regarding when it comes to court proof that he's the only one who has used these photos in any way. And because of that, the applicant hasn't met her burden. My client shouldn't have to get on the stand under oath and deny this. I can tell you he's going to, but he shouldn't have to get on the stand and deny this right now because the proof is not there. And because of that, we would ask for it to be dismissed at this time. If you feel like you need to hear from him, I believe he is prepared. And I would like to have just a quick, 30 seconds with him if you needed to hear from him. But I don't believe that would be necessary based on the level of proof. The DeKalb County Police, and I'm assuming there's a police department that has investigated this case on the other end from wherever the employees received the communications. So we have at least two different police departments who have investigated this case, and charges have not been brought. And as we know, regarding the way that the system works, oftentimes when there's not enough evidence, the police will advise, hey, we're not bringing these charges because we don't think that there's enough, but you can take a warrant application. I believe that that's what's going on here, because if there wasn't enough evidence, they would have taken a warrant. So we would ask that this case be dismissed because the evidence it doesn't amount to probable cause in this situation, Judge.
All right. Now, Ms. Goodwin, so what he's essentially making a motion to have the case dismissed without him producing or stating any evidence. What I'm saying at this moment is that he has a right to testify or not to testify, and if he subsequently testifies, that would be a product of whether or not there's any tangible statement. Do I think it's possible probative? I don't have any, I'll be honest. We haven't heard any testimony that directly links him to it, but other than the evidence that you've made mention that he's the only one who's provided. Obviously, there was a police report where he's alleged to be the person who has made these particular or disseminated these photos. If I have him testify, which is again his authority, right to testify or not testify, then that is up to him. So I am going to, at this juncture, before I let you speak, this is their case in chief. I'll ask them whether or not they want him to testify or he's allowed to testify. If he doesn't want to testify, that is his legal right. And so, counsel, I will make that question to you, and then you tell me what your client wants to do, and that'll determine how we proceed.
Yes, Judge. 1 second.
Your Honor, did you get the other emails I was sending to you?
I don't believe so. You needed to send them to the magistrate court warrant app if you had any, but I haven't seen anything other than the police report.
Okay, I submitted a few other police reports in addition to photos, and now I'm going to submit a voice message.
Again, are these related to the July 6th incident?
Not specifically July 6th, but it's all the harassment and the communication that has led up to the July 6th incident.
Okay, well, I haven't seen that evidence specifically. Okay, counsel. Fair enough, as we're taking a brief recess for them to communicate.
Judge, I'm advising my client not to testify. I don't know if you want me to continue with argument, but no,
Well,
we're not.
Okay, that's fine. So this is what we're going to do, Ms. Goodwin. So I just want to make sure that you understand this process. He has a right to testify. You have a right to maintain silence. That is a constitutional privilege and right. So what you're going to be able to do at this juncture is I'm going to give you an opportunity to make an argument to the court about why you believe, based upon the evidence that has been presented, that there has been sufficient probable cause for an arrest warrant to be issued. And so it is 7:34. I'll give you 3 to 5 minutes to make that argument regarding the evidence that's been presented and why you believe that the court, or that you've met rather the probable cause standard for the harassing phone calls, as well as the prohibition of disseminating nude or sexually explicit photos regarding Mr. Doan.
Okay, thank you. So I feel like there is more than sufficient evidence regarding the harassing communication and even emails, Your Honor, that's led up to this case which took place in July. You see with the several different police reports that I've submitted over to you about the harassment, the evidence from the situation that took place in March when he was actually arrested for domestic violence. And then when he just showed up at my house in May and left my house after pouring water and gasoline and water inside of lawnmowers with gasoline around my garage. And I had to contact the police again then. It's been non-stop harassment from this man up until the point where I literally had to change my cell phone number. Then it just picked up via email. Jeremy is not going to stop what he's doing. Jeremy is a very smart man and is very calculated with what he does. So I'm hope you guys really hear my voice right now and understand that this is the last thing that I ever wanted to do was sit up and talk about what took place between Jeremy and I relationship to where Jeremy would even go to be in trouble for anything. But this is not the end of it for Jeremy. Jeremy's not done right here. Especially if Jeremy gets away with this right here, it's just going to be something more else, but it's going to be worse than this. And unfortunately, this is being recorded. So later on down the line, if this man comes and kills me, which he is very capable of doing, he's told me how he would do it. You guys have this recording to look back at and wish you guys would have stepped in and maybe dug a little further to see the capabilities of this man. I'm still waiting on the investigation that has been launched by the Department of the federal government, the ethics department with this job, because my job filed a complaint with them. I don't know what else I can say or do, but the fact of I've been stupid for not pressing charges on Jeremy before, for not keeping the communication, okay? But I'm telling you now, there's ways that you can retrieve text messages from cell phones. There's ways that, Your Honor, the courts can even subpoena Microsoft to have that IP address obtained. Microsoft has the capability of doing that with the subpoena. You guys will see that this is nothing but Jeremy, and Jeremy's going to do whatever he can to wreak havoc over my life. It's evidence that I've submitted. Police have been called over 7-8 times regarding Jeremy since 2022 to today's date.
Let's see. So first things first, Miss Goodwin, the concern obviously is really with you. I do have a great concern for you. I've seen the report. I understand the seriousness and the frustration that you must have gone through and that you're still going through, knowing that your colleagues have seen photographs of these that are supposed to be private and shared between you and another person. I understand the frustration that you're currently feeling, possibly even with the legal system, because of what you feel as if you know in your heart based upon I guess either interactions and things that you've experienced. With all of that being said, though, and as I always will tell everyone, I am bound by what the law requires as far as the standards of determining whether or not there is sufficient evidence for probable cause. With that being said, I have the report. I have seen that they're not from you. We know that you didn't do this. We know you wouldn't do this to yourself. And someone obviously has it out for you. Someone obviously does not want you to succeed in the life that you have or try to hold you back. And I hate that. I do. I hope that whoever subsequently is responsible gets found out and gets punished, right? But unfortunately, at this juncture, though, I don't have sufficient evidence for Mr. Jeremy Doan to be able to establish that he is, in fact, the person to do this. Though I do find that your testimony is true. I don't find that you are saying anything that is a lie. But unfortunately, the evidence that you've supplied does not directly tie Mr. Doan to these actions. And if that is the case, I don't have probable cause to issue an arrest warrant. You understand? And so in the event that you do find sufficient evidence that identifies the appropriate person who caused this to you, this harm, court would be happy to hear from it. But because we don't have that, we are not able to issue an arrest warrant at this time against Mr. Doan. and as a result, it'll be dismissed. But Ms. Goodwin, though, I do pray that you do find some type of resolution to this matter, and I hope that you were able to keep your job ultimately, because obviously this wasn't something you would have committed for yourself. But that's going to be the order of the court. Yes, ma'am. And you folks are free to go. You as well, Attorney King, and as well as you, Ms.
I'm going to
Attorney
hear
your
Kim
case,
as well.
Mr.
Thank you,
Simon
Judge.
Jr. You're going to have an
Thank you,
opportunity to tell me all about it. All right. And then as well, I'll go through all of those things. On the other, in addition to, then I will hear the cases of Brown, Johnson versus Harvey. And then I will last hear the case of Mickle and Perry. And then
May I say something? May I say something on that you'd probably like to hear? In the interest of the court taxpayers, and based on, I do understand that you know what you're talking. I heard you tell me what the probability is.
I didn't give you the probability as far. Oh, you're talking about getting the information back.
Right, absolutely. With regard, yes. I'm, I've never been in any issue like this. So I would say to you is that I would be rather. I've had time to think about it, and I understand what you. In addition to what you are telling me now, I would just go ahead and dismiss this matter rather than put you through yours home. I understand where I stand.
This is my job, and this is what I do. Don't say it's for judicial economy. I'm here.
No, I respect
what you have to say.
I respect understanding that you know what you're talking about. You're the judge. I'd rather, Your Honor, save the court the time. And based on, I understand what you're saying to me. I will come back once I have what I need.
I understand. So
I'll dismiss.
You would prefer to voluntarily dismiss until you
I would prefer to
pursue.
Right. And that's my sister. I'd rather not hurt her.
That's true. You guys are family members.
We are.
Like blood family members?
Absolutely.
Let me tell you guys something. I'm going to tell you this for your
Tell
own
us.
personal knowledge. Listen, me personally, right? You guys are family members. I always have the strong belief that if you can't work it out before you and your family member, when you come to me, when you come to the judge, you better be on your P's and Q's. You understand? Because if you're going to go after your family member, that means you better have exhausted all other opportunities to resolve, right?
Yes.
Because I'm not here to be nobody's Maury. I ain't nobody's Jerry Springer. We don't deal with family issues unless we deal with criminal issues, right? Because we send people to jail. So just want to let you know that. So if you feel as if this might, quote unquote, waste the court's time, then that's fine. I will let you dismiss the case voluntarily. In that regard, then, Ms. Coleman, you would be dismissed as well.
Sir, please let me say something, please.
Well, let me, Ms. Coleman, listen. Let me stop you so that you understand that there will be no need to say anything.
Yes, sir. But I got it. I need
No. You don't have to say anything because I'm telling you, don't say anything because I've already said it. The case is being dismissed because he's asked it to be dismissed. And honestly, if he subsequently let me inform you. In the event that he subsequently finds that evidence, he would be free to bring it if there's actual evidence, right?
But can you leave
listen to me. This is an adjudication on the merits. He wanted to dismiss voluntarily. He has the absolute right to do so. This is not a civil claim. You don't have a counterclaim. You understand? Yes, so again, you guys are family members. Go have that conversation off camera. But you guys are free to go. Detective Moore, thank you so much for your time. All right.
Thank you, sir.
Thank you, Your Honor.
So what we're going to do here, if you guys didn't see in the previous or the first hearing, I'm going to proceed in your matter in the following way. I'm going to give each person an opportunity to speak about between 3 to 5 minutes to give me a little bit of background. I always stress to people that I want the background to be about the subject matter that we're here, not about what happened in 2015 at a barbecue or something like that. Okay. I want to know about specifically what's going on in the matter that is of issue. And that would be here an allegation of criminal trespass damage. Okay. And we'll talk more about specifically those allegations. And then I'll give people an opportunity to introduce any witnesses or any evidence that you have. And then I'll let the other party do the same. And then I'll make a determination on whether or not to issue an arrest warrant. With that being said, let me confirm. Ms. Harvey, do you have any witnesses here with you this evening?
Yes.
Where are they?
He's on camera.
All right. I'm going to get Mr. Talley. Mr. Talley, how you doing? Good evening. We're going to put you in a private breakout room so that you can be sequestered, right? And they've already done it. Chop, chop. Ms. Brown Johnson. Oh, no, they have not. Mr. Talley, we're going to move you. There we go. So he's sequestered. Will you need to have him testify, Ms. Harvey? Or if you need to have him testify, we will bring him back. Do you have anybody else? Okay. How about Ms. Brown Johnson? Do you have anybody?
I do not.
Okay, good. And everybody's emailed me all their evidence that they intend to use before we get started so we can have a smooth go.
Yes, sir.
All right, excellent. All right, so we've got everybody under oath. So let me set the scene about why we're here. We're here specifically on the allegation of criminal trespass. That is an allegation against Miss Lanice Harvey for an event that happened back on March 9th, 2023 at 12 p.m. And so, Miss Brown Johnson, let me just ask you guys aren't family, are you?
No, we're not.
Good. No,
We
good.
we never met.
Okay,
together.
good. No problem. No problem. Just want to make sure. All right. So Ms. Brown Johnson at 7:55, I'm going to give you about 3 to 5 minutes to hear or so, which will be around 8 o'clock, 8:01 for you to tell me what's going on and what happened on this March 9th, 2023 event that led to this application. Floor.
Miss Harvey's son and actually her husband, who is her witness, the two of them had come to my niece because her son had ran away, and obviously my niece had sent an Uber for him, and so they thought that he was still at the house, and he wasn't. And Miss Harvey was demanding that my niece tell her where he was. And so by the time I arrived, she was saying that my niece was a liar, and she was demanding that basically she tell her where he was located. And I was saying, hold up, wait a minute, she's a child. I don't think at the time she knew my niece's age, which she confirmed for me when we were in the breakout room. She had no idea of her age. I said to her, they're both children, and both parents, you and the other child's mother, you both should be responsible parents, and you should know where he is just as she should know where her child is. So I told my niece to get in the car. My niece got in the car. I'm talking to her through the rearview mirror of the car, and as we drive off, I see her hand. She throws the rock at the car, and she's throwing it at the window, but because the car is moving, I assume she was throwing it at the window, but because the car is moving, it doesn't hit the window, it hits the side of the car. And that's basically what happened.
Okay. All right. Miss Harvey, do you have any statement or opening that you'd like to make regarding this matter? It's about 7:57. I'll give you till about 8:02.
So she's right. Both my son, her niece sent the car over to where we live at from DeKalb to Newton or whatever. I called the police, and the police was like, they're gonna go find him. But this is the first time my son actually ever left home. So we did some investigation, and we went into the Instagram and found the little girl address and her mom information, which I actually sent over everything. I was in communication with her mom. When I approached the little girl, her mom was on the phone. Her mom told me to call the police, do whatever you want, because she actually I'm sorry, I got a headache. She actually spanked her and she ran out the house or whatever. But my son has spent the night at the young lady house because her mom works at night. So I just want to know where my son was. And the little girl, she was constantly lying. So I was telling her that she's lying about the whereabouts. And obviously she was, because there's plenty of times in the hearing, in the breakout room, she admitted that
Well, hold on. I want to tell about what she happened in breakout.
Oh, right. Oh, sorry, breakup. Well, not her. I'm not talking about Miss Rosalind, but Queen's had the little girl lies, but my son lies well. So, she got in the car, and what I did was I took a picture of the car, the license plates number, just in case, because the little girl mom said she don't know who that was. So I sent it to her, and I sent the proof of the message to y'all, and also took a picture for my sake so I can go back to Newton County to show them the information. I was in contact with the police as well. Like every evidence I got, like the address, anything, I just showed them evidence because I don't know where my child was. And at the end of the day, DeKalb County, a lot of juveniles sometimes don't end up making it back home. So I wanted to collect any evidence I had. When we took off, I got a message from the little girl telling me, well, she gave me the address where my son was finally, but she said, I want the information of your daughter. And I was like, my daughter's at school. Well, you must be the daughter. You threw a rock at my car. And I said, I didn't do no such thing. I didn't even know what was going on until they actually sent that message. Then when I went and got my son, the officer, he called me from the little girl phone, asking me my information. So no, I didn't give the officer my my information because the little girl constantly played on my phone, which I sent those information as well. Sorry, my head is really throbbing. So literally, I've been connected with her mom back and forth about our kids' behavior. But like I told Ms. Rosalind, I have no intent to throw anything. I don't have a criminal record. I'm in school. I don't do stuff like that. There's no reason why I would have to throw at your car. I took a picture and I showed you the picture. I actually showed her as well. And and I actually showed the message that I sent to the little girl mom, which is her number, to show her like, hey, your little girl got in a car with this person. Here's their plates. I didn't do any such thing as throwing anything. I'm sorry. I'm not a violent person. Never been a violent person.
Got it. I got it. All right.
All right.
No problem. Miss Rosalind Brown, did you email some evidence over to me?
I did. I sent you a picture of the car. It's a brand new car. I just purchased the car.
Okay. And what I only saw it's only, I'm going to share it here. Give me 1 second.
It's a 2022 Toyota Cross. It's the first.
No, I got it. All right. So is this the photograph that you're talking about?
Yes.
Okay. And this was to have occurred back in March, right?
Yes.
When did you first? Go ahead. I'm sorry.
That's the picture right now. I
Okay.
just took that just a few minutes ago.
Did you have any? Let me see if you have some other photographs. Hold on.
No, I don't have any other photographs. I just sent the police report, the estimates.
Okay.
You mean pictures prior?
No, not pictures prior. You don't, and you have no witnesses, correct?
No, I don't.
Okay. That's fine. I'm going to ask you some evidence because again, it's you guys, and I just want to see, make sure I get some clarity here. Who are these young people and how old are they?
So the young lady, my niece, is 12, and she is correct. Her mother was not home, and I'm gonna be full disclosure.
No, it's fine. Listen, we've all been 12. Some people have been hot. As I get it. So that's I can gather that. How old do you know is her son?
I think her son is 13.
Okay. And is the allegation that he took an Uber to this young lady's house while her mama was at work?
You know what?
That's not a crime that we're investigating. So if that's what happened, that's just what happened. Anybody going to jail over that? At least not for me.
I'm not going to say that her mother was at work. I'm not going to say that her mother was at work.
Either way, a young person.
Her mother, she was
took a car to this young lady's house.
And there was no adult supervision at the house
what time
overnight.
of the evening was this?
According to the messages.
Hold on, I'm going to get to you, Miss Harvey. Believe me, we're going to ask.
I don't think she got the.
Hold on, I'm gonna get to you. I just want to see what she knows. Okay, but anyway, it's at a time where an adult's not getting around. Assumingly, Miss Harvey doesn't know where her child is because of the time of the evening, or he hasn't, whatever. And so he must be. Was the young man found at your home or your daughter's home? I mean, your sister's home.
No, he wasn't found there either. He was not at her house. And that was the issue. I think when she went through his messages, that the messages indicated that that's where she would find him. However, he was not there when she got there.
I understand. And I guess this is a 13-year-old child, because I don't care how grown you think you are at 13, you were a child.
You're not.
So I get it. We're dealing with two children, effectively, middle schoolers, for God's sake. All right. So 2 middle schoolers have now subsequently, their actions have led to a lot of hustle and bustle. All right. Hold tight, Ms. Brown, Ms. Johnson. Now, Ms. Harvey, if you can take yourself off me, thank you so much. So just so I can understand here, and because I don't want to waste you guys' time, because I can see where this is potentially going. Your son, did you find him, and where did you subsequently find him?
I found him because the little girl sent me the address. She paid for him another Uber to get to a friend's house because he actually he met her from the skating ring that Saturday, and he was linked up on Wednesday. I got
listen, that background information I appreciate, but it's not as relevant. Obviously, look, listen, we all, if they're blessed to live another 10, 20 years, right? And I'm sure they will. This will be water under the bridge, hopefully for them in their grand scheme of biography. But ultimately, let's talk then about this rock here. Ms. Brown Johnson, tell me what evidence or what information that you can provide that shows that Ms. Harvey is the one that threw a rock and damaged your brand new vehicle.
I saw her. I saw her throwing the rock. But she's saying, no, when you saw me, I was actually just, what you saw me doing was taking a picture of your car.
Okay.
No, I saw her throwing.
Okay. All right.
And there was like a loud thud to the
Okay.
car.
All right. Was there anyone else in the car with you?
My niece was in the car.
Your niece was in the car, the young lady. Okay. All right.
She-
Listen,
yes.
I know you're trying to protect young people, but I get it. I'm mostly concerned about you. All right, Ms. Harvey, let me ask you some questions.
Yes.
Ms. Harvey, Ms. Brown Johnson is saying that you threw a rock, but did you throw a rock?
No, I didn't throw a rock. And it's crazy because she even said that she just saw my hand move. She didn't see me throw a rock. And then I sent you evidence to show from the niece conversation with my son. She didn't see it. She just assumed I did it because she said I was the only one out the car.
Oh, hold on. I know you
All
said.
that's in the evidence. I sent you all
No,
that.
I get it. I got these text messages, but I want to see exactly.
She wasn't the only one outside of the car. It was she and her husband were both outside of the car.
Okay, hold on. All right. Now, Ms. Harvey, this was sent to me or sent to the court regarding this, and there is a photograph of a car. Is this?
That's to the girl mom to show you. I literally took a picture of the car. I sent it to the mom as well. As soon as I took the picture, I had it from my records, but I also wanted to send it to her mom. That's her mom number. And this
That's
is
the back of my car.
Okay, hold on. I'm gonna let you guys speak just like one at a time.
I'm sorry. I let her talk. I can.
No. So I just so Ms. Harvey, is that the photograph that you took that you're saying that you took when you were at the location?
Yes, I took evidence to show. Yeah.
Okay. Now, Ms. Brown Johnson, is that your car?
That is.
Okay. Can you recall if that was the location? I don't know if you can tell where your car was when you guys subsequently had that interaction. Now, let me go put it back just to see if you can refresh your recollection here with this photograph. Give me 1 second.
That's my car parked. That's not my car moving.
Okay, where is it parked at?
She had a
In the
blinker light
drive.
on.
That is true. Your lights are on, but maybe you just put it.
I can't.
It's all good. Your lights are on.
It's not parked. She was
I got Miss
leaving.
Harvey. Hold tight. I can. It's all right. You don't have to. I can see all of that. But Ms. Brown, is that the location where this
Yes.
event occurred? Okay, Ms. Harvey. Let me ask you. I'm just not saying it is or not. Do you know whose car that is in the black?
I don't know who car that is.
Okay, just want to make sure. All right. So this is it. She's taking a photo. All right, good. All right.
See the wheel is turning.
No, it's okay. It's all right. So this is what I'm going to do. Miss Harvey, I've seen the text message. I know it doesn't specifically say that anybody threw the rock or anything like that. What I'm going to do at this juncture, I'm going to give the parties an opportunity if there's no other evidence. I know, Miss Harvey, you have your husband. Would you like to have him testify?
He can.
Do you? And I'm just curious. Other than him being there, I assume he would indicate that you didn't throw a rock.
Correct, because I didn't throw the rock.
I get it. I just don't want to have evidence that comes in that doesn't necessarily offer anything different than what we already have presented. So let's do this. Ms. Brown Johnson, I'm going to give you an opportunity to make a closing argument regarding if you don't have any other evidence or testimony about the basis of the fact or regarding the probable cause that she's committed this action. And then I'm going to have Ms. Harvey produce her own statement to it as well. Okay.
Okay. Well, Miss Harvey was very angry. When she got there, she was very angry because she wanted Carmaya to explain to her where her son was. She was also very angry that her son had ran away. And my position was, it is not the child's responsibility to know where your son is. It's your responsibility as his parent to know where he is. It's her mother's responsibility to know where she is. It is her mother's responsibility to know that your son was at her house. That's the responsibility of responsible parents. From my perspective, and this is just me, they're both irresponsible. And I said that as much as that. And I think when I told Cormaya to get into the car, there was enough talking. And I also, the way that she got the address is from me. I instructed Cormaya to reach out to her son to get the address from where he was located so she could give it to his mother. And once I stopped the communication, because she wanted to go back and forth, it enraged her. She was very angry. She was very, very angry. And so once I stopped that communication, and she was like, well, how do I know that this address is the correct address? I was like, you know, that's the only information that she is going to give. There's not going to be any more back and forth. You're not going to berate her. You're not going to call her a liar, because ultimately you're the parent. It's your responsibility to know where your child is. And she was angry. It's just that simple. And that's why she threw it.
Last question before I let Ms. Harvey give her closing. Where was the damage located on the car?
On the passenger side, on the side panel, like after that window.
Okay. All right, Ms. Harvey, I'm going to give you an opportunity in about 3 to 5 minutes to give an indication of why you don't believe in a probable cause has been met and why an arrest warrant shouldn't be issued.
Okay, well, first off, she didn't see me do anything. She's assuming I did it because I was outside the car. I showed evidence to show I took a picture. I wasn't angry. I even sent you messages. Sorry, I even sent you screenshot of messages between me and her mom. I was not angry. I was upset, but I wasn't angry. And I would never push myself to get that angry to damage anybody's property ever, ever. I go to church. I don't do none of this type of stuff at all. And I know we're not supposed to talk about the breakout room, but I ever discussed this with her. I'm just wanted to find my son. Why would I throw something at your car and then I won't find evidence with my child? That doesn't make any sense. I even called the cops, and I sent you screenshots of that as well, of all the communication of cops. So why would I have a reason to throw something at your car and then keep calling the cops? I just wanted to find my son, and all I did was take a picture. And you're basically saying I'm guilty for just basically taking a picture because you assume I threw something, and I showed you the evidence. You know, you said your car was parked, the blinker light was on, and you was actually turning out. That car was not parked. You was actually turning out. So I wanted to get the picture of the car before you leave. But that's all I gotta say. I'm sorry. My head is really throbbing, but I'm sorry.
Well, listen, folks. This is obviously a serious situation, and what more serious, I even think, than the allegation of the damage to property is obviously young people, because obviously this has created a lot of trauma and drama here, with young people obviously trying to maneuver as grown people, and in some ways grown people shouldn't even maneuver. But nonetheless, their actions have led to this interaction, and this is unfortunate. And I'm not even going to truly comment on the children's actions, but obviously kids, I guess, shouldn't have cell phones because they just feel like they can do whatever they want to. But look, my job is to determine whether or not there's probable cause, whether or not there's been sufficient evidence that has been made in order for an arrest warrant to be issued. I don't have that here with the allegation of criminal damage to property. Ms. Brown Johnson, I understand that can be frustrating because you have damage to your brand new vehicle and you solemnly believe that it was Ms. Harvey that subsequently caused it. But I don't have at this juncture any sufficient evidence to supply that she was the one who committed the act. And so I understand that this is an issue that may be affecting you beyond just the damage, because you may have an insurance claim or whatever else that you may be able to deal with that. But nonetheless, for it to be on Ms. Harvey, for her to be responsible criminally, which I will still say doesn't mean that she has any monetary due to you or academic or even pay anything, even if she was. I just don't find that there's sufficient probable cause. So what I'm going to do is obviously dismiss it. But I will just say, obviously, I hope that these children are sufficiently reared in a way that this does not happen to anymore. Okay, because I understand the stress of feeling like your son. Listen, they put young men in sex slavery too. They do all them things and too. So I understand your frustration with trying to find your son. I understand why you would be so diligent in trying to find his location. And so I understand, and prayerfully that doesn't happen again. If you got to put a tracker on the young man, you got to do it. Same thing with the young lady, but thankfully there is safely with their parents' care. But in as far as this particular hearing is concerned, the case will be dismissed and you ladies are free to go and put that baby to sleep. Okay. Thank you guys for your time.
How you doing?
All right. Mr. Mickle, can you unmute for me? And is there a way for you to turn your camera so I don't have to look at you with the longitude? You got horizontally here. I get a horizontal view of you. I don't like to have to turn my head. I ain't gonna lie to you, man. I got a little bit of a neck pain. And I don't want you to continue to add to that.
First, let's unmute.
Okay.
Let me see if this one.
Tell me, do you have any witnesses with you?
Hang on. Hold on. See, that's why we didn't want to try to do anything.
Click on the X, it should go away.
Restore.
Click on the X and this should go away. Click on the X and this.
I did.
Damn.
I did.
Well, go back and click on this. Click on this.
Being images.
Just move to the left over here and click on something over there.
Okay.
There you go.
Okay. The only thing we could possibly try is to move. Wait, maybe it's the other one. No. I don't know. I think we're gonna have to leave it because we may end up, losing you altogether. And we don't want to do that.
Okay, well, let's just stay the way you are. Don't stress.
Yeah.
Click on that so at least it'll go in the.
Okay, so listen, let me ask you again. Do you have any witnesses that are going to be testifying?
Yeah, my sister is a witness.
Not to the actual harm, but the background of the physical harm.
Well, I'm here about the event that we're here to talk about. I'm not here about a whole lot of other events.
Okay.
Okay, I had requested some witnesses and I thought they had been subpoenaed because I received this subpoena notice and I thought they had been subpoenaed.
They have not. They have not been subpoenaed. So it would be you and whoever you currently have with you.
Okay.
Well, what are the options? Because again,
we can continue it, but Mr. Perry, let me ask you this. Mr. Perry, do you have any witnesses with you?
No, sir. No, Your Honor.
Did you email any evidence?
No, I did not. I didn't know this was even coming, Your Honor. I didn't know what was going on.
Okay. All right. Well, listen, Mr. Mickle, if you're not prepared, I can continue the matter. If it's not, have you guys been in court before? Is this your first time?
Yes, this is my first time, sir.
Okay. All right. Well, look, Mr. Perry and Mr. Mickle, this is what we'll do. Mr. Perry, I don't want to inconvenience you because obviously you're a respondent, but that doesn't make you a defendant. But he did have an understanding that there would be an opportunity for him to have other parties here. You yourself don't have any evidence or anything, and I don't want you nor Mr. Mickle to essentially have your case be heard without an opportunity for you to feel like you truly can either defend or present your case. You understand? And so I'm going to have it reset. What my clerk is going to do. Clerk, can we give them a date certain now? That way we don't have to deal with them having a notice that they feel as if they cannot appear to or appear for rather.
What's my sticky note?
Okay. May I ask a question?
You sure?
To clarify. Okay, we sent an email saying these 3 individuals at this address, we wanted to subpoena them because they said you have to send an email or message to MAG, whatever, saying these are the people and the addresses you want to subpoena. No one said that we personally had to subpoena because
you wouldn't personally subpoena them. You would get them served or somebody. You listen. You gotta. These actions are generally, either free or they cost a little money. But there's work that goes into getting people subpoenaed, and then the people who are subpoenaed have to be compensated for their time to come and testify. If they're not a witness that's going to testify for you freely, they have to be. There's rules about being subpoenaed. You just can't say, "Hey, come," because I said, and then not either compensate them and or get the person appropriately noticed to subpoena. There are some legalities to things.
Well, we were not apprised of any of
it, and that's why we're gonna get it continued.
Okay,
so that you can have that. But again, if you have witnesses that are unwilling to testify on your behalf, yes, that's what you need to get them subpoenaed. But if these are people that you know, call them, ask them to appear. They don't have to be subpoenaed for them to be present to testify on your behalf.
Okay, could I ask about the information and documentation that we submitted? Because
I'm gonna be 100 with you right now. I don't know much about that. That would be more for the clerks.
but I submitted the information and they told us that the judge would review.
I
what
don't
was
know
submitted.
what specifically they're talking about me reviewing. But when it comes to your subpoenas being reviewed, that is not necessarily something at this juncture because they haven't even been served.
I understand, but there's a pattern to the physical abuse related to insurance money and everything else.
So listen.
Okay,
You're asking questions and trying to ask questions that subsequently are going to lead to us discussing the evidence in this matter. And we're not doing that this evening because you guys are not prepared. So
Okay.
we're not going to pre-try or preview the evidence at this juncture because that would not be what we're going to do. So we're going to continue it. What I was asking then of my clerk is to see if we had a date certain today. Or do we need to just email them a notice about when they'll be reset?
No, the earliest that we have is the 16th of October.
That's fine. That gives them plenty of time. So Mr. Perry, Mr. Mickle, we're going to reschedule this for the 16th of October. It'll be 6 p.m. Mr. Perry, if you want to either get counsel, if you want to get some witnesses, or you don't want to do anything at all, that is your prerogative and your right. Mr. Mickle, if you want to get whatever evidence or witnesses together for that event and that date, please do so. But again, if you come unprepared next time, then you will not get any more continuances other than ones that require such based on the law or certain extreme circumstance. Okay, so you guys got plenty notice about what to do now. Even this won't be your first time next time. Okay, Mr. Perry, do you understand?
Yes, sir, I do.
All right, Mr. Mickle, I will see you guys on the 16th, possibly. All right, you guys are free to go.
Thank you, Your Honor. Thank you, sir.
Thank you.